Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to clear up a little bit of confusion as to what happens when someone, for example, is convicted of an aggravated felon or deported, and they're not able to get back to the U.S. or they don't think they can get back to the U.S. and what the difference is between deportability or removability and admissibility. Okay, this is somewhat of a fine line in immigration law, but it can make all the difference in the world in trying to get back to the U.S. Okay, so I'm not going to go into all of the different things you need to do in order to get back to the U.S., as I have lots of other videos on those different subjects, but I'd like to delineate a little bit of an issue here that many people have. So for example, let's just say that they're convicted of some gun charge. Okay, let's say they're convicted of a gun charge. They had their residency in the U.S., they're put into deportation proceedings or removal proceedings, and they're ordered removed, and they are removed from the U.S. So the question then becomes, okay, they were removed from the U.S. Because of a gun charge. Now can they come back? And again, not dealing with the issue of permission to re-enter or different other types of waivers that they might need. There is an absolute difference between admissibility and deportability. Okay, basically look at it like this. There are two different columns in immigration law. One column deals with deportability and or removability. Okay, and those are basically for people who are in the U.S. who do some kind of criminal act that makes it so that they are assuming they, the order is issued, that they are removed from the U.S. because of that crime. This has nothing to do with admissibility as to whether they can come into the U.S., what crimes make them inadmissible, and so forth. There are two different things. You have to keep that in mind. So, for example, someone has a gun charge which makes them removable because in the law, under the column that deals with why somebody can be removable, specifically there are provisions regarding possession of a firearm and gun charge and so forth, and that makes them removable. Now, let's move to the other column in immigration law, the one that deals with admissibility, being able to come into the U.S. In this particular regard, the column that deals with what makes someone inadmissible or unable to come to the U.S. is different than what makes someone deportable. So theoretically, one can be deported for a particular crime that does not affect their ability to come back into the U.S. And as strange as that is, one reason I used a gun charge is there is nothing in just with possession of a firearm and so forth, or unlawful possession of a firearm, there's nothing in the inadmissibility statutes that make that particular crime inadmissible. So somebody, minus the other issues, can come into the United States, be petitioned, not even have to do a waiver on a certain crime that got them deported from the U.S. As strange as that sounds, that is the reality of what can happen. So there's other examples as well. For example, somebody can be convicted of any one of a number of what is referred to as aggravated felons. Okay, aggravated felonies. Now, there is a whole list. I mean, I could go down and spend the next 10 videos describing what is and what is not an aggravated felony. But suffice it to say that aggravated felonies certainly make people deportable and removable, but there's nothing specifically in the admissibility column that deals with aggravated felonies. You're not going to find any provision in admissibility statutes that say if someone has been convicted of an aggravated felon, they are inadmissible to the U.S. Okay, you're not going to find it, and so in some cases, strangely as it may sound, it might be better to try to get voluntary departure if you can, and then once you turn around and try to be admitted again, the particular item that made you deportable might be able to be made so that you can come into the U.S. and you're not inadmissible, or that it is easier or even possible to get a waiver of something in the inadmissibility column. So let me just go over a little bit what are some of the items in the inadmissibility column. And again, this is when essentially you're outside the United States and you want to come back into the United States, or you want to come into the United States for the first time and you have some kind of criminal history. That's the fact. Now, there's all kinds of stuff that we could talk about, other items in the inadmissibility column, such as, becoming a public charge, health-related grounds, and so forth. But I'm concentrating on the criminal grounds because of the link between in the deportability column, how that does not correlate necessarily what's in the inadmissibility column. So one is that you have been convicted of a crime involving moral turpitude. Now, just as a teaser, basically, I'm going to do a video next week solely on what is and what is not a crime of moral turpitude, because if you have been convicted of one, essentially minus a waiver, you're not coming into the U.S. But sometimes you don't need to argue the waiver. Sometimes it's better to look at the statutory provision of what is and is not a crime involving moral turpitude, argue it is not a crime involving moral turpitude, therefore no waiver is needed. Okay, so there's different types of crimes of moral turpitude, but generally speaking, there has to be an intent on the part of the person who committed the crime in order to have some kind of argument, at least on the government side, that it is a crime of moral turpitude. So let me give you an example. Let's say you're driving and you got in the car after you had 32 beers, okay? And they take the breathalyzer test, and it shows you have a blood alcohol level of 1.3. Well, that's not a crime involving moral turpitude because it didn't take any, what they call in the legal terms, mens rea, or intent in which to commit the crime. There is, simply stated, they take the breathalyzer test and you are or you are not drunk, period. No intent to be drunk. I mean, you obviously intended to drink the drinks, but as far as just the DUI itself, the statutory provision says if you have a certain level of alcohol in your bloodstream, then you are legally drunk. So that would be that. Now let's say that we're talking about hitting someone, assault or battery. If the statute essentially says that you intend to cause fear in someone else, or you intend to hit someone, then of course that does take a mental capability in order to do it. It does take an intent in which to commit the act, and therefore that would most likely fall under crime of moral turpitude. But it depends where you are. It depends what state you're in. It depends how it's statutorily defined. There are some states that do not define assault or simple assault as having any intent. I mean, theoretically, you could be on a bus and, basically bump into somebody and be technically committing assault, even though you had no intent to do it. So the reason I'm bringing all this up is, it's not clear cut, which is good in most immigration cases because it leaves a lot of room to argue that it is not a crime of moral turpitude. Okay, so that's the first thing, and then obviously there's issues with juvenile crimes and whether that even comes into play as a crime of moral turpitude. There's also the issue of whether it is a petty offense, and I'll get into more about this with other videos, but if it is a petty offense, then someone is not inadmissible if the crime is, if it's a crime of moral turpitude. Okay, so in that case, it can very well be a crime of moral turpitude, but they're not inadmissible because it's under the petty offense exception. And go ahead and email me, if you want to get information before my next video on it, on what exactly a petty offense exception is. Now, I'd like to give you some examples of crimes that are have been considered crimes of moral turpitude, and some that are not. Okay. Now, but before I get there, again, there's also the analysis, what they call the categorical and modified categorical approach as to determining whether it is a crime of moral turpitude. I mean, I'm here to tell you that there is a lot of legal argument that can go forward in order to properly determine whether or not a crime is or is not of moral turpitude or not. And if you look at the cases, again, there are some cases that as you go across the country have different adjudications of whether they are or aren't. So a lot of times it does depend where you're going to basically enter the U.S. as to what jurisdiction falls under whether or not you are admissible or inadmissible. Therefore, when I'm advising clients, depending what they may have convicted, depending on the facts of the case, they may be advised to enter at a different part of the country than they may have wanted to in order to fall under that particular area of law where it's more favorable to them. And so you have to look at all kinds of reasons why something is or is not. There are other issues as well. What makes somebody inadmissible based upon a criminal history, and again, go ahead and email me for more specifics in it. But like for example, there's cases out there that say the following does not involve moral turpitude, such as simple assault, aggravated assault, assault and battery even. There is various cases that say child abandonment is not a crime of moral turpitude, delinquency of a minor, various domestic violence cases. So, sometimes it doesn't sound intuitive as to what is and what is not, but don't let, for example, another train just look at your crimes and say, oh, you're not admissible. Because there's a lot of analysis that has to be done, which might be able to get around the inadmissibility through legal argument and showing why it is or it isn't. And so, again, the theme of this particular video is you can be deported for a particular crime that makes you deportable or removable, yet turn right back around and come back into the United States legally without being inadmissible for the same crime that made you deportable, or to have arguments that exist on the inadmissibility side that did not exist on the deportability side. I know this might sound a little confusing, which basically it is. But if you like the video, go ahead and click like, click subscribe. I usually do videos once a week. Go ahead and email me, and you can also self-schedule an appointment for a free consultation. More on the coming videos. Thank you.